Welcome to the 42nd meeting of the Fair Employment and Housing Council. My name is Gabriel Sandoval, and we're going to start with calling this meeting to order. I'm going to ask my colleague, Kara Brodfear, the Senior Fair Employment and Housing Council, to perform the roll call.
Thank you. Chair Sandoval.
Present.
Councilmember Brodsky.
Present.
Councilmember Hong.
Present.
Councilmember Iglesias.
Present.
Councilmember Alude.
Present.
Councilmember Schur.
Present.
And Councilmember Walensky.
Present.
Well, I'd like to thank you for joining us today in this council meeting. The meeting is being broadcast live via Zoom. Please note that the link is in this meeting and all future meetings is publicly available on the DFEH website. Also, a video of today's meetings, as with other council meetings, will be made available afterwards on the DFEH website and DFEH YouTube channel. I also, at this time, kindly request that you subscribe to the DFEH YouTube channel. We also have closed captioning available, which can be found at the bottom at the Zoom bar features, denoted by CC. You can chat with the Zoom administrator if you have difficulty accessing this particular feature. For those members of the public who are participating remotely today in today's proceedings, you may have noticed that they are currently muted and your video is disabled. However, please be advised, as with all council in-person meetings, there will be opportunities for you to provide public comment and participate throughout the meeting as we address each agenda item. We have a number of ways for you to participate and provide input. You can send an email to the council at fehcouncil@dfeh.ca.gov. We will be checking this email account throughout today's meetings, and your comments will be read aloud and considered by the council members. Alternatively, you can use the Zoom chat feature to send a message directly to the meeting administrator, who can read your comment out loud. Or if you would like to speak directly rather than through your written text, please click raise hand in the Zoom feature or press *9 if you called in. If you would like to rename yourself in the Zoom list of participants, you can find yourself on the list and click rename in the list of the options next to your name. At this time, I'd like to introduce also those who are participating in us from our colleagues at the Department of Fair Employment and Housing. We have Kevin Kish, who is the DFEH Director, Adam Romero, who is the DFEH's Deputy Director of Executive Programs, and we also have Kara Brodfear, DFEH Senior Fair Employment and Housing Council. Thank you to all those attending. We look forward to your participation during today's meetings. But I also like to introduce, and it gives me great pleasure to do so, the new council members who have been nominated, who have a record of public service and civil rights advancement, who will be joining council members Brodsky, Iglesias, Schur, and me to carry out the important duties of this council. We have Helen Hong, Adedunji Alude, and Julie Walensky, and I would like to invite each one of them to introduce themselves as new members of the council. Why don't we start off in alphabetical order? So Helen, Councilmember Hong, would you like to introduce yourself?
Yes, it is my honor and pleasure to serve along with all of you in this really incredible role. My background as an attorney and as a professional has always been advancing the social justice in many different fields, from education, legal, and social services. I actually started as a public interest attorney and became an executive director of a legal aid program here in Los Angeles, focusing on the rights of primarily women, immigrants, primarily who are undocumented, and teenage parents. From after leading that organization for 7 years, I moved on to work with transition age foster and probation youth between the ages of 18 to 25, supporting their educational and employment goals. Most recently, I actually came from the State Bar of California, where I was their first director of access and inclusion, where I ran the Justice Gap study, really identifying and engaging the civil legal needs of Californians, not only who were low income, but moderate income throughout the state. So I am so pleased to be on the council, and I really hope to really engage community input throughout the state.
Welcome. We're excited.
Thank you.
Thank you. Councilmember Alude?
Thank you, Chair Sandoval, for the warm welcome. Am I getting is it echoing? Any
There's
chance?
feedback.
Yeah.
There isn't feedback. Can everybody mute who's not talking? Let's see if that helps.
See, is it any better now? Oh, great. Okay. Just a bit about myself. I work for the Judicial Council of California, the policymaking body of the California courts, and help to implement the council's policies pertaining to judicial training. Prior to working for the Judicial Council, I was a civil litigator first addressing discrimination in the realm of housing and consumer finance, and later in workplace discrimination, whistleblower retaliation, and wage and hour lawsuits. I began my work in the law and child advocacy, serving unaccompanied minors in deportation proceedings and diverting youth from the school to prison pipeline. And I decided to join the council because I'm reminded of the People v. Hall case. In 1984, just a few years after California became the 31st state in the Union, the California Supreme Court issued a decision categorizing Chinese alongside Native American and Black people as lacking status to testify against white people in court. The court ruled that the testimony of a Chinese man who witnessed a murder by a white man was inadmissible, largely based upon the opinion that the Chinese were a race of people whom nature has marked as inferior and who are incapable of progress or intellectual development beyond a certain point. And as such, had no right to participate with us in administering the affairs of our government. We have yet to dismantle the unfounded and toxic stereotypes that cast entire communities of color, immigrants, religious minorities, and LGBTQ persons as dangerous threats to our country. And I believe that I and many more members of these groups must participate in administering the affairs of government to bring this nation closer to achieving its democratic ideals. And so this is why I'm ecstatic to be joining the council and doing this work. I look forward to working with the DFEH representatives, fellow council members, and the public to implement consistent and clear civil rights regulations.
Thank you, Councilmember. Welcome. Councilmember Walensky?
Good afternoon, everyone. I'm honored and very excited to serve in this role. I'm an attorney at National Center for Lesbian Rights, which is a nonprofit organization in San Francisco. I've spent most of my career representing plaintiffs in civil rights cases, including cases involving race, sex, LGBTQ, and disability discrimination. I also previously worked at the Santa Clara County Council's office, where my work included advising county entities on California's non-discrimination requirements. I'm very much looking forward to working with members of the public, fellow council members, the department, and other stakeholders. Thank you.
Thank you, Councilmember. And again, a warm welcome to each and every one of you and for the contributions you will make on issues of advancing civil rights in the state of California. So welcome. We're going to review the agenda. We are, I want to let all those who are participating that copies of the agenda and meeting materials can be accessed on the council's page of the DFEH website, which is the same page that the Zoom link conference link is available. Highlights of today's meeting will be focused on updates from our various subcommittees. We also will have further consideration, modification of the regulations focused on housing. And before we move on to that, I would like to take the first item on the agenda, which is the approval of the minutes from the council's December 4th, 2020 meeting. Do we have any edits or changes to the council meeting minutes of the December 4th, 2020 meeting? Seeing any public comment?
No public comment in the chat or by email.
Okay.
Chair Sandoval?
Yes.
One just thing I noted, I believe that Director Kish provided a report during the meeting, but he wasn't included in the above as DFEH staff present. I wasn't sure if that needed to be
So I
updated.
am technically a council member. And I was going to, even though I am a non-voting one, so typically I am roll called at the beginning and not included among DFEH staff. But at the end of the day, it doesn't really matter.
Okay,
I'm
great.
to be included in whatever way that I can.
Sorry,
Call
Kevin.
it a teachable moment. Okay. So no edits, no public comment. You said, Kara. Okay, so then can I get a motion?
This is
move.
Sarah. Move to adopt the minutes.
Can you get a second?
I second. Tim.
Can you get a roll call, please?
All right, Chair Sandoval,
Aye.
Councilmember Brodsky,
Aye.
Councilmember Hong,
I'm sorry, should I abstain since I wasn't there? I'm going to abstain.
okay. Councilmember Iglesias,
Aye.
Councilmember Alude,
I'm also can abstain.
Councilmember Scher,
Approve.
and Councilmember Walensky.
Abstain.
Great, thank you so much. So the next item on the agenda are council members' reports. Does any council member have a report to provide?
Gabriel, the only thing I maybe we can report on the LA Human Rights Commission press conference during our subcommittee.
That would be great. We could address what's been going on in terms of these important issues during our committee report out. Does that work for you? Great. Okay. If there are no other council members who would like to provide a report at this time, we will now listen to Kevin Kish, and so he can provide his report. Okay. Director Kish.
Thank you. I just want to thank our new chair, Sandoval, for seamlessly taking over from the first and most recent chair, Chaya Mandelbaum, who, as you know, stepped down at the end of last year. I want to really warmly welcome our new council members. It is such a wonderful group to be able to be a part of. I'm thankful to the governor and his appointment staff for appointing talented, committed civil rights advocates to this body. And this is the first time, I believe, I was just checking, since 2017, the first time in 4 years that we've had a full complement of council members. So I'm really excited to see what this body does in the coming months and years. Very quick department update. As most of our stakeholders know, large employers of 100 or more employees with at least one employee in California have a new pay data reporting obligation. The deadline is the end of this month, March 31st. Our portal is up and running. Please visit our website to learn more, see the portal, download templates, access frequently asked questions, and a user guide to uploading your reports. We have also launched a newsletter that comes out kind of every 2 months, sometimes a little bit more, depending on what's going on. You can subscribe to this on our website, or you can see the newsletter on our website and subscribe directly to the newsletter. It comes to you via email. And it includes things like upcoming public events and trainings, new outreach materials, case filings and settlements, and any other information that we're trying to reach the public with. We have implemented the expansion of the California Family Rights Act. So as everyone, I believe, knows, on this body, the job protected leave provisions of California law were extended from larger employers of 50 or more employees to all employers of 5 or more employees, effective January 1st of this year. We have a California Family Rights Act toolkit on our website with tools to help folks understand their rights and comply with their obligations. And then finally, I wanted to flag 2 public outreach initiatives. One, I know many of us are alarmed and horrified by incidents and reports of anti-Asian bias and violence in recent days. This is not something that is new in recent days. It's a pattern that we've been seeing over the past year and before. And I just wanted to alert everyone that DFEH partnered with the Stop AAPI Hate campaign to put on 2 webinars last month about understanding and preventing anti-Asian bias. And those webinars are publicly available on our website and YouTube page, and I encourage stakeholders to take a look. And then finally, DFEH has launched what I believe is the first formal public outreach campaign in the department's more than 40-year history called Keep California Fair. Again, you can see the materials on our website, but this outreach campaign involves videos, radio spots, posters, including posters that are on food trucks visiting workers in fields throughout the state, as well as social media. So please visit our website for more. And if you happen to hear one of our spots or see a video pop up in your internet searches, then that's great. And I hope that you will help us spread the message to people in communities across the state who too often do not interact with government. That's what I have for the department. And let me, before I close, ask Adam and Kara if there's anything that they think that we should highlight that I've missed.
That was comprehensive, Kevin. Thank you.
I agree.
Great. So we'll move on to the next item, and that is related to item number 7, which is consideration of further modifications to housing regulations regarding definitions, intentional discrimination, discriminatory advertisements, statements, and notices, consideration of income, residential real estate related practices, and disability. So I'll hand it over to Council members Dara Sher and Tim Iglesias.
Thanks very much. Dara, I think I'll do the first part and you do the second part. Okay. So welcome everyone. And I also want to warmly welcome our new council members. This is fantastic. And just to give you context and any members of the public who hadn't been following along, this is the second set of housing regulations that we've been working on. As you probably know, California has had very progressive fair housing policies well before the federal government for a very long time, but there were no regulations ever developed to implement them. So the first set we did, which was effective, I guess, beginning of last year, was the first set ever of fair housing regulations to implement California's fair housing law. And this is the second set. And so we're taking it bit by bit and focusing on different issues to sort of implement the statute. So this is the text we have before us and that we will be asking you to approve for a second 15-day comment period is something we've made some revisions to after the first 15-day comment period. I know when I started the council, it was very difficult to follow this wavy lines and all this text to follow the changes. So definitely ask if there's any questions. What I'm going to do is highlight the changes that we made in the first part of the regulations, and then Councilmember Scher will highlight the changes we made in the disability part of the regulations. So the first change that we made, if you have the document before you, is on the second page. Or excuse me, it's with regard to intentional discrimination in Article 3, intentional discrimination, section 12040 under definitions. And in the last council meeting, it was requested by a council member that we change the word something to anything for easier clarity. So we changed that. Then the next change that I want to emphasize is in that same article under section 12042, which is burdens of proof and types of evidence in intentional discrimination cases. If you go to C3 there, we have added a provision in response to a comment about making sure that when there's an expression of express bias, that is explicitly recognized as counting as direct evidence of that could prove intentional discrimination. Then the next substantive change we made is in that same article, but it's now article or section H. We've added this article completely, so it's new. And what it does is it articulates the factors that come from the Arlington Heights case, a famous housing discrimination case under the federal fair housing law. And it makes it clear that the types of factors that were considered the basis for a possible discrimination case in the Arlington Heights case can also be considered as either part of a prima facie case or to rebut an affirmative defense under California's law. The next substantive change we made is in that same article now it's under section I, burdens of proof in cases involving indirect evidence of discrimination. So I3, what we did was we added a phrase. So now it reads, if the respondent meets the burden under section 12042G2, the complainant must show that the non-discriminatory reason asserted by the respondent is pretextual, false, or not the only reason. So we added that last phrase because under California's fair intentional discrimination rule, all the complainant has to show is that the discriminatory intent was a factor. They don't have to show it was the only factor. So we just wanted to emphasize that there. And then later in that same section, we added, we moved some, excuse me, let's see. Yeah, we moved some text from there to that new section H that we added. So that's why there's some text crossed out there. The next change I want to indicate is later in the document in Article 6, which has to do with discriminatory notices, statements, and advertisements. So in the first provision of that, section 12050, called discriminatory practices regarding notices, statements, and advertisements, we added a couple of phrases that were recommended by agency just to expand and make more complete the scope of the coverage there with regard to that it's unlawful for a person to make, print, or publish or cause to be published a notice, statement, or advertisement with respect to the sale or rental of housing or accommodation, which indicates any preference, limitation, or discrimination. And then we added, or an intention to make that preference, limitation, or discrimination. And we made some other similar changes just to expand or rather make more complete the scope of the provisions. The next thing I want to mention is in that same article, 12050, but section G, we didn't actually change this section, but I recognize we need to, and what I'd ask the council to do is add in the word or in section G1A at the very end, in between the phrase no vouchers or government assistance accepted, and then insert or before no wheelchairs allowed. It's the last of a list of examples. So if we could do that, that would be good. And then just a couple more in that same section, and now I'm talking about G2. We again made a couple of suggested edits by the agency just to make sure that it's clear that these provisions apply both to current buyers and prospective buyers, as well as former owners and buyers and renters, so that the scope of the provisions are clear as to time, if you will. The next change is in the next section, which is 12051. So exceptions to liability for discriminatory statements. And here we made a couple of changes. The first one is or actually just one, this section A. There is a statutory exception to liability for a discriminatory statement. And what we've done is to try to clarify what the scope of that statutory exception to liability for a discriminatory statement is. And below, I'll talk about in more detail in section 12141B, we make clear and specify what kinds of exceptions there are to that exception to liability. And here we're just cross-referencing it because there's also in the statute a exception to liability for discriminatory statements with regard to inquiries with regard to source or amount of income. So that's really just a cross-reference we've changed. And then the next, just a couple of changes in Article 13 down below. Article 13 is called consideration of income. And what we're doing here, California, the statute, the legislature many years ago made source of income a protected basis, but then only recently made it clear that that meant and refers to and includes any kind of governmental subsidy or voucher for housing. So we're trying to make sure we catch up with the law here. So in that section, Article 13, consideration of income, under the first section 12140, definitions. In response to a comment, we have revised section B to add the phrase, provided it meets the requirements of section 12140A2. So what this does is, what we do is we lay out a number of examples of lawful verifiable income, but in response to a comment, what we're trying to do is to make clear that the list of types of income that are included under B have to meet the law. They have to be verifiable. So that's what that is, just to make that clear. And then just two more. So under 12141, which is called source of income discrimination in rental housing, we have added under A, we've added A1 and 2, basically to make more complete and explicit what types of actions count as adverse actions from the standpoint of what of discrimination under source of income. This is a very, as some of you may already know, very complicated problem and something that's kind of new. And so we're trying to kind of make it clear what people who are subject to this need to do. And so we've added a couple of additional statements of what counts as adverse action there in 1 and 2. And then later in that same section under B, we've added a couple of things under B. We've revised B1, and then we've added some things in B2, 3, and 4, and 5. And those are the more specific examples of what kinds of statements and questions are not liable for violating the source of income discrimination. So this is trying to, again, clarify the scope of that exception for liability. So that's what that is. And then I just have one more, which is the last thing, which is section 12142, aggregate income. Here, in response to a comment, we have tried to make clear what the statute requires with regards to a housing provider treating people who are married and people who are planning to live together but who are not married, how they have to be treated in a similar way with regard to consideration of their aggregate income. And here we've rephrased it to try to make clear what the statute requires. So that's the changes that we've made in this part. I don't know, Councilmember Sandoval, if you want to wait till the end after Dara has spoken about the disability parts to solicit any questions or whatever, however you want to do it.
I think that would be best.
Okay.
Councilmember Sure. Thank you, Councilmember Iglesias.
Hello, everybody. And I definitely want to welcome, to echo what's been said about being very excited about the new members to the council. We are really thrilled you are here and looking forward to working with all of you. I think just to recap what I think both Councilmember Iglesias and Chair Sandoval have said, this round of draft regulations has gone through 3 public comment periods already. The first 45-day comment period and then 2 15-day comment periods. And the latest changes that Councilmember Iglesias has been highlighting and I will highlight are changes that we've made in response to the 3rd set of public comments. And what will happen today is if the council approves this version with whatever changes it makes today, it will go out for another round of public comments before it is finalized and sent off to the Office of Administrative Law for final review. So just so everybody understands where we are in the process, what we are highlighting today is not all of the changes from the existing regulations, but all of the changes since the last round that was considered by the public. And all of my changes are in Article 18 relating to disability, starting at page 23. And the primary change here was that in the previous round, in the existing regulations, we dealt extensively with reasonable accommodations for people with disabilities. This set of regulatory changes addresses reasonable modifications, which are changes to the physical premises as opposed to policies and procedures. And we have added reasonable modifications in a variety of places into this article as an obligation of owners addressing addressing requests from individuals with disabilities for accommodations or modifications. So I am going to flag the changes we have made since the last round, and I'm not going to go to every single one, but I'm going to highlight some of the more specific ones. Starting on page 26, which would be in section 12176 F. F8. There was a request at the last council meeting to add in some headings to the examples to provide a better roadmap to the examples. And you will see there are now headings to subdivision 8B, Roman numeral 1 through Roman numeral 4. These headings are not changes to the text or the substance. They are simply intended as a guide to folks to direct them to the general topic being considered in each of those examples. So I wanted to flag that in a number of places in this article, we have now added more direction to people about the content of the various examples, and in some cases, some additional cross-references, so the examples have more context and more of a roadmap for people reviewing the regulations. And we did that at the request of the council from the last meeting. The next place, I believe, where we made changes, and Councilmember Iglesias, feel free to stop me if I miss something that you believe is a significant change, is in 12.179, denial of modifications. And again here, starting on page 35, in 12.179 D6, we have added headings to these examples. We have also added some language clarifying in example Roman numeral I, where modification is a repair required by building codes or standards. We've added a little more clarity as to the relationship, the process and the relationship to the building codes or other legal codes that require that the property be maintained, and more cross-references. And so the new language is, because the California housing codes generally require proper maintenance of accessibility and structural features, the modification is reasonable because failing to repair the railing also violates the duty to maintain the property. Therefore, the owner is responsible for repairing or replacing the handrail at the owner's expense. So this goes to where modification, a request of modification by an individual with disabilities actually is a required repair, and therefore the person who pays for it is not the tenant with a disability. And this is a situation of an individual with a mobility disability who needs a handrail, but the existing handrail is broken. The second place, and then as you will see, we added headings in the next two examples. And then where we made some additional changes are in section 12.180. And again, you will see that we have added as requested captions in section 7 to provide more direction as to the owners, as to what the examples are about. The other thing we have done in those sections is clarify the appropriate cross-references, so they no longer respond simply to the interactive process, but they reference all of the requisite procedural requirements for considering the request for reasonable accommodation or modification. And they, in some instances, highlight a particular reference section of the regulations that's particularly relevant. So, for example, the first one, example of circumstances where removal of carpeting may constitute a reasonable accommodation, that references B, 12.180B, because carpets have historically been treated by the courts in some instances as an accommodation and in some instances as a modification. accommodation generally, if there is hardwood flooring underneath, then all the owner needs to do is pull up the carpeting. That is not considered a modification. However, if there is not a finished subfloor underneath, then example 3 might be if one that talks about whether it's a reasonable accommodation or modification and who has to pay for it. And in all 3 of these examples, it is usually a reasonable modification or accommodation, but who has to pay for the changes may vary depending on whether it's considered an accommodation or modification. And because it is a common request and an area of great confusion, we've tried to be a little more specific here and added a little more cross-referencing. And then you will see under C, beginning on page 37, we have added, again, in many of these examples, additional cross-references for clarity, as well as additional headings, which do not change the substance. And then the next significant changes from the last round are found primarily in, again, in 12.181, beginning on page 43, you will see additional headings and cross-references for clarity, improved cross-references. And that goes on through a number of pages. And then we have, and that is the primary change we have made in most of these sections. And I think that's it. I mean, we made a lot of changes in the last round, and these are primarily the changes that we've made in this round. I think the most significant text changes are probably in section 12.181. N as in Nancy, examples of reasonable modification 3, 47, where we provided some additional clarity in condominium units to make it specific that the owners have to consider a request for reasonable modification in the apartment and cross-referencing what they need to do. We had a little text language there in addition to the cross-references. So I think, unless Councilmember Iglesias thinks I skipped something, I think that is the thrust of what we did in this round for clarity. And I'm not seeing that Councilmember Iglesias has anything to add. So
That's fine. It's fine.
Well, thank you, Councilmember Schur and Councilmember Iglesias. I'm going to open it up to the other council members for comment or any other items of clarification that they would like to address at this time.
I'd just like to, thank you, everyone. I just want to offer another reminder about where we are. So council members can propose changes that the full council could vote on today to move a modified text into a public comment period. Typically, those suggestions in real time during the hearing are typos or small changes that don't require a lot of reflection. After this draft is considered by the council today, you will vote to move it into public comment. And for members of the public listening, that is the period. You're of course welcome to comment today, but during the new public comment period is the period where your comments must be considered by the council and responded. Thanks.
Thank you, Director Kish.
So This is Helen. I actually just have a couple of edits, if that's what we want to go through now. Sounds like Kevin's key was appropriate. So on page 12, the section actually that Councilmember Iglesias spoke to, I believe that's a typo for section I 2 and 3. I think the section should be corrected for that. So I'm looking at page 12, subsection I, number 2. If the complainant meets the burden under section 12042, that section should be I, not G, because the G is now I.
Yes, thank you very much. That's excellent.
So that's correct for both 2 and 3.
Yes,
So we
that's
want to
correct.
change that. The next one is under page 14. Under section G 1A, instead of us, it should be is. Along, so right, it's is
right, the
a
second
lawful-
word.
Yeah.
Yes, thank you very much.
And then also then to repeat your addition of or before the last clause, before wheelchairs, no wheelchairs allowed.
Yes.
Page 15. This was a question, whether or not for section 15051, subsection B, whether or not the exception should apply for a person available to only of one sex or gender. I wasn't sure why sex was used as opposed to another descriptor, but that's a question for the subgroup. If I defer to the group. On page 19.
Helen, hang on just a second. I think that's a good question. It's not a change we made in the last round, but it is one we can consider.
Let me check the statutory language, because I'm thinking we drew from the statutory language, but that doesn't mean your suggestion isn't a good one. But it'd be good to get clear on what the statutory language is.
Great.
Thank you. Page 19, Article 13, section 12140, subsection B3. It's the last phrase for foster care benefits, including benefits for youth up to the age of 21. I would recommend that we actually put that up to the age of 26. There are some foster care benefits that are to 25 or 21 that provide specific housing vouchers. And so I don't want to limit it to just the 21. I mean, or alternatively, just don't put any age, because there is some fluidity to that. So that was my suggestion, to eliminate 21 or to put it up to 26.
Do you have a preference, Helen, as to whether we say for foster care benefits, including benefits for youth, or just foster care benefits? What would be preferred language?
I would, for the sake of providers and for young people, I would say up to 26, because then it's very clear. Most of the advocacy has been pushing it up to 26. There is some push to 30, but right now the advocacy is as to 25 or 26. So I think that should be sufficient. And then on page 20, similarly, so this is the same section B5, the last phrase for rapid rehousing for homeless individuals, whether or not the goal was very specifically for rapid rehousing because that subsidy goes to the tenant, or do we just want to keep it broad for just housing assistance? I mean, because RRH is very specific dollars. And so I wasn't sure why it was that specific.
I think the intent was to capture existing programs, but if there are other programs and this is too narrow, I think we would certainly consider broadening it if you have alternative language.
Right, and this is meant to be a non-exclusive list.
Yeah. Okay. Just because I know for, especially in certain counties that have other, I mean, rapid rehousing is a term of art. So based on funders, so whether or not we just want to say housing assistance for homeless individuals, I think would allow more flexibility. That would be my recommendation, but that's that.
Well, these were specific examples. So, and they are all specific programs, but we could say rapid rehousing or other similar assistance.
Yes, I like that language better.
Okay.
Yeah.
Council member.
Yeah, I agree with that.
And then page 26, under section B, regarding when a request for reasonable accommodation or reasonable modification can be made. This was more of a clarifying question. In the second sentence, it says a reasonable accommodation request that is made during or following a pending unlawful detainer action is subject. So I thought the pending didn't add any more clarity than the during. So should it just be or following an unlawful detainer?
I'm sorry, I'm lost. Where are you exactly?
In the middle of page 26, section B, capital B, second sentence. A reasonable accommodation request that is made during or following a pending unlawful detainer action.
So I think the intent was to make it explicit. That it could, to make it very clear that it could be done at any point during the UD proceedings or after the UD proceeding.
Yes, but the pending is what throws me off. So if we take out the pending or following an unlawful detainer, I think it's clearer that it's during or after, unless the pending was as to the specific. I don't think any, but.
May I ask a question or add to that confusion? It sounds like when you say after the pending, that it still has to be pending, and that if it's all done, over with and done, you can't do it anymore. So I think there is a difference in the meaning.
So the proposal is to take out the word pending.
Correct.
Correct.
I mean, if you want to be even more specific, you could say, or after judgment has been entered.
I think we say that somewhere else. We have an example.
You have an example of it later on where the example is very clear, but I'm saying for that, I mean.
We also say in this section, including after judgment or physical eviction. But I would tend to agree with this comment. The only thing I would say is, if not everybody feels comfortable making that kind of change in real time, this is one that could be made after or during rather the public comment period. But I personally I understand where Councilmember Hong is coming from, and I think that it's a good point.
I'm comfortable deleting the word pending, and I do think we've covered after judgment. So I'm fine deleting the word pending, and I appreciate these edits.
I agree. Just to go back, if Councilmember Hong, did you have more, or?
I do. I just have two more.
Great, you keep going.
Okay.
This is great. You're hitting the ground running here.
It's the benefit of fresh eyes. This hasn't been my third time around, so.
It really helps. It helps to have close proofreading. Thank you, and new eyes.
On page 33, subsection C, new 3, I would suggest the deletion of workmanlike in parentheses. You actually talk about competent manner later on, and this is the only time that you reference workmanlike, which isn't very descriptive in any way. So I would suggest that that's just deleted unless it's part of case law or some other people tend to use it.
It is a term that has been used by HUD in some of their guidance documents, which is where the term came from. I can take a quick look and see if it's in the existing statute or regulations. I'm trying to remember exactly where it came from.
I recall that there was discussion around this word because it's also obviously gendered. And the idea was to put it in parentheses and quotations because it did reference other areas of law, but that the primary word that this body would use would be competent.
That's my recollection as well.
Right, I'm just trying to remember the source of it. In terms of reasonable modifications, because I thought it was either regulatory or statutory, which is why we did this.
Well, in that case, Councilmember, and with Director Kish's example that it has been discussed, and that's why it's presented that way, I'm happy to retract my deletion.
I think it would be good to figure out where that word came from, just confirm whether it's statutory, regulatory, and if it's not, to eliminate it. Because I agree with you, Director Kish and Councilmember Hong.
Okay.
Now, I think we all had concerns about the word, which is why we rewrote it. And I'm just trying to figure out, give me a second. I have section 12955 of the Governor Code up, which is where I believe this comes from. And nope, wrong section. Hang on. I think it's worth trying to take a look at this right now and see if we can't resolve it. If folks don't mind bearing with me for a minute. Because I know we were concerned with it.
Sarah, I think it's from the joint statement from TUD DOJ.
Yeah, so in that case, I don't know that we need to keep it in. It's not in, I just checked the statute and it is not in the statute. So if folks prefer for us to delete it, I could do that. It did come, I think you're right.
In the chat room, Wendy Prout wrote that it appears in 24 CFR 100.203.
Oh, thank you, Whitney. That's probably why we kept it in, because it is a term used in the equivalent federal regulations. And we try and make sure we meet or exceed those requirements when interpreting California law. And what was it, 100.203?
Yes.
24 CFR.
It was a considered decision to leave it in. So this is one that I would propose that we not try to modify during the hearing and take back for further consideration based on this input.
Oh, okay. Yeah, I think where I come down, I mean, we're happy to go back for further consideration, but given that site, and thank you, Whitney, I do think I would prefer to leave it in the parenthetical.
Okay.
It makes it just a little easier for
Yes.
court trying to do the translation.
Just two more small bits on the same page on section 4 on the second sentence. Whether a requirement for restoration of an interior modification is reasonable is a case-by-case determination. So delete that S.
I'm sorry, I'm trying to track you.
Next paragraph,
Mhm.
second sentence. just deleting the extra S after determination.
Thank you.
And then on that same section, on the next page, under little I,
Mhm.
oh, actually, no, I think that is, I wasn't sure if that or was supposed to be an and, but I think it is supposed to be an or.
I believe it is supposed to be an or.
Yes. Those were my thoughts. I mean, they were not substantive. Everything else looked really good to me and it was clear. So thank you so much for all your work on this.
I really appreciate the input a great deal.
Yeah, that's really great. I'd like to come back to one of your suggestions. I did look up, Councilmember Hung mentioned in section 12051 exemptions, B, which currently reads, for a person sharing the living areas in a single dwelling unit to use words stating or tending to imply that the housing being advertised is available only to persons of one sex. I did check, and that actually is the statutory language under Government Code 12927 C2B. But I think that in interpreting the statute, since California has moved beyond a very narrow notion of sex, my proposal would be to expand that to include the current protected classes. So to have it be that it reads, the housing being advertised is available only to persons of one sex, gender identity, gender expression, or sexual orientation. I think that would be an appropriate interpretation of the statute in terms of that exemption, but that's the way I would interpret what you're saying. So I just...
Well,
Tim, do you, I don't have it in front of me, in some other section, do you have an all-encompassing definition of sex, which we do in the employment regs? So,
yes,
sex can be used inclusively.
no, we don't in the housing regs at this point. And I'm a little concerned about expanding this at this point because it's an exception that really narrows protections. And so I don't know that I want to go beyond the statutory language.
Well, maybe this is one we can go back and look at.
Okay.
Yeah.
And I want to visit, I'd love to hear, any other council members have any concerns?
This is Julie. I had an additional suggested edit to raise on page 15 in section 12050, subsection G5. And that it's in this section on discriminatory notices, statements, and advertisements. And in G5, I would suggest where it says prohibition based on a protective class, changing protective class to say any protected basis under the Act, which would make that section consistent with the language in the subsections immediately preceding it.
Yes.
4, 3, 2, etc.
Yes, that makes sense. Thank you.
And I also just wanted to respond to Councilmember Hong's comment about sex. I'm looking at section 12926R of the FEHC, which defines sex, and I would be inclined to leave it as is because that is the statutory language, and to the extent it may include other terms, I don't want to suggest that that there's like a legally distinct, that adding that there would be a legally distinct meaning among adding other terms into the exception, and would suggest just leaving it as is.
Thank you.
Thanks.
Thank you.
Any other council member comments?
If we don't have anything from anybody else, I want to go back, take a look at something briefly on page 21.
I had just a minor
Oh, go ahead.
comment.
Please go ahead.
Let me see, let me find it. So
Go ahead, Councilmember Lude.
on page 39, and it's 12180C4. Myself. And in that, the example provided for reasonable accommodations, it's discussing the loan modifications sought, but refers to mortgage company and mortgage lender in the paragraph. And I would recommend use of mortgage servicer because a loan modification is sought. And hand in hand with that, sort of the fourth sentence, this accommodation may be necessary because without it, ... it ends, and so receive the loan, but it's a loan modification. So adding the word modification at the end of that fourth sentence.
Okay, so I'm sorry, let me make sure I got this correct, because I think you were changing lending to servicer, or were you just changing something else?
Well, in the paragraph that's used mortgage lender and mortgage company.
Mm-hmm.
And I would, my recommendation was for all of those to read mortgage servicer.
Does it, I appreciate this is one of your realms of expertise, do all banks use a servicer, or sometimes a bank is its own servicer, or you know what I'm saying, in terms of whether.
So it's very uncommon now for a mortgage company that originates a loan to actually service the loan, and all modifications to the loan are sought from the entity servicing the loan as opposed to that originated the loan. But I think it's sort of all encompassing. Even if the loan, it's a rare occasion where the loan has stayed with the entity that originated the loan, they will still be servicing it.
Mm-hmm.
So the correct term instead of mortgage lender should be mortgage servicer?
Mortgage servicer, yeah.
Mortgage servicer. Okay, and then you also suggested without it, Tuan may be unable to sign the loan modification application.
And so receive.
We don't really.
A loan modification.
We don't really need to say and so receive the loan, because that's not really what's happening there.
If you were to add modification at the end, it keeps.
Okay.
I think it's finances, but.
Okay. Okay, I think I've caught that one.
And I just have a question about something on page 19.
Okay.
It's 12140B3. And it may be phrased this way, sort of based on the statutory language, but in terms of lawful verifiable income, there's payments from parents, guardians. I wondered if there's space for parents to be relatives, only because there's another instance later at 12178G5 sort of contemplates that they care for an elderly person or care for one's child, but here it sort of excludes that that care or financial assistance might come from a parent or otherwise someone with a legal designation. And so I didn't know.
Would family members be better
Um,
than relatives?
yeah. Well, I think either could work. But relatives is used
Family
later.
members is more consistent with like CIFRA and the other, stuff just than relatives, but.
Mhm.
That seems like an appropriate change to me, particularly with the example of children paying for elderly parents. So
Yes, and I don't have a strong feeling as between family members or relatives. I think relatives, well, I understand Councilmember Brodsky's idea or desire for parallelism. I'm thinking family members might be construed as more narrow than relatives. And I'm not sure we will.
On it, but I also know that we have a representative from the California Apartment Owners Association who's here, Whitney. So maybe when we open this to public comment, if I could specifically invite her to weigh in on this proposed change, I think that would be helpful for us to hear before we make a final decision.
Sounds good.
And then just to be clear, based on everyone else's input, I withdraw my change regarding the comment Ray sex.
thank you. So I would like to go back for just a second to page 21, B3. Because I believe that somehow we have a duplication in here. 3 says, for the purpose of verifying the level or source of income to confirm eligibility for tenants of protection. And 4 says, for the purpose of verifying the level or source of income to confirm eligibility for rental assistance and other tenant protections. So I don't think we need 3. I was just trying to go back through some of our drafts to determine if we actually deleted some earlier text, but it may just be a drafting error, because I would propose that we delete the duplicate 3. And I
while you're there, Councilmember Short, there's also looks to be an extra period in section 4, between disaster and only if.
Oh. No, that should be a comma.
Okay.
Well, thank you for catching that. Yes. So I guess my proposal, and I'm just trying to double check here, and maybe we can make this change pending public, for the moment. It would be to delete number 3.
Yeah, pending. Yeah, I think we should delete it for now. And then if we find out that something has been accidentally omitted, we can add it back in.
Okay. Yeah, I'm not seeing it. I think that is what we intended there. And I think it's just a drafting error somewhere along the way. So on that section, then We would delete 3, renumber 4 as 3, and correct the period to comma. Okay, I don't have anything further here.
Councilmember Shore and Councilmember Iglesias, I have a couple of questions and items.
Okay.
On page 11, we have C 1, 2, and 3. And I would consider, or would you consider rearranging that so it starts off with direct evidence includes an express condition, followed by the new language where it says direct evidence also includes, and then the first element will now be the third. So if direct evidence or it just seems to flow better that way.
So I'm sorry, repeat that again, please, the proposal?
Direct, it's just a restructuring where you would have number 2 is now number 1, and number 3 is now number 2, and number 1 is now number 3, C3.
There's an error here. I'm glad you caught this. This is actually supposed to be a D. Number 1 is supposed to be a D.
Okay.
And so it would move down to D, and all of the subsequent sections would be renumbered.
Great.
Because it is not an explanation of direct evidence, it is a statement of a combination of direct evidence. If I'm recalling correctly, Councilmember Iglesias.
Yes, that's correct. And so, yeah, so as you're saying, that means all the subsequent sections change, as well as the 2 subsection cross references, which Councilmember Hong mentioned should be I, are now going to be J, I think.
And one item, again, I don't know, this is something that if you want to address it now or later, this is an item that I believe was addressed during some of the last meetings, so I didn't raise this as an issue, but on page 6, the definition of military or veteran status, it looks like T6 has some duplicative language because military or veteran status definition says includes, regardless of duty status or discharge status, a member or former member of, and then it says 6 is any person determined to be on active duty or formerly on active duty status pursuant to, and then the code is provided, regardless of duty status, which seems to already been addressed during the general kind of description, regardless of duty status or discharge status. So is there some way to make that more clear? And then also with regard to the last item, T7, it says any person determined by a court to be a former or current member of active military service. I would propose or recommend that that be included part of the general statement provided under T. So it'd be military or veteran status includes any person determined by a court to be a former or current member of active military service and a member of a member or former member, regardless of duty status or discharge status, comma, of, and then list those.
I'm sorry, can you say that again, Chair Sandoval?
Sure. So I think, again, this is a proposal that you would have something to the effect of military or veteran status includes any person determined by a court to be a former or current member of active military service or a member or former member, comma, regardless of duty status or discharge status, comma, of, and then you list the items 1, 2, 3, 4, 5, 6, and 7 will be deleted.
The reason we didn't do that, just so you know, is that most of these are statutorily determined, but there are some circumstances in which courts have interpreted them. So it is not only the courts that make this determination. If the intent is to ensure that we So I think it is a different finding. All of these others are folks who have been determined by statute or previous decisions to be a member or former member, and they are just examples. It is not an exclusive list. But then there are some sort of outlier court decisions and maybe some future ones. So I do think we don't want to limit this whole thing to determined by a court, which is why it's a separate subsection, but maybe it's a drafting issue. I do believe that we don't.
Yeah, I'm thinking it's disjunctive as opposed to conjunctive. So you could take a look at that and see if there's, okay.
Well, so one of the reasons, well, I'd like to try and resolve as many of these things as we can today before it goes out for public comment, so that we have the most complete decision for the public. I agree with deleting regardless of duty status in 6, because I agree as I read this, it is duplicative. I'm happy to take back and consider the proposal to move 7 into the primary definition. I'm not sure I have a particular phrasing that works at the moment unless there's something more specific.
Yeah.
That was good.
I agree with deleting regardless of duty status in 6 and then taking the other suggestion under consideration.
That's fine. Thank you. Okay. Any additional comments from council members regarding this particular matter? Okay. Do we have any public comments on this item? I know we would like to enlist some participation from some of those who are in attendance, but
Yes, Chair Sandoval, we've received some comments via email and chat that I'll read now. And then if you would like to speak, just press the raise hand button. We already have a couple in the queue, and then I'll unmute you. So I'm going to go ahead and read the email that we received first. This is from Paul DeMott. Dear FEHC Council, in a cursory review of proposed section 12051 exemptions, page 15 of attachment B, this phrase in section B seemed peculiar, available only to persons of one sex. I have not thoroughly considered alternatives, but believe it may raise gender identity concerns. There must be a better way to convey the regulatory intent. See generally Chapter 5, Employment and Housing Council, Subchapter 2, Discrimination in Employment, Article 5, Sex Discrimination, Section 11030, et sequitur. Thank you for your consideration and all that you do. So that was a comment from Paul Dumont, and then we have a comment in the chat, which I will also read out loud. This is from Connie Arnold. One of the problems with newly constructed apartment complexes with accessible apartments is the complete lack of accessible roll-in showers. These units are needed, but the law only calls for accessible tubs. With the population aging and the numbers of persons with mobility disabilities in the state, we must have an addition for roll-in showers. The lack of roll-in showers is very discriminatory toward the disability and senior community. And Ms. Arnold goes on to say, one of the biggest obstacles to getting a reasonable accommodation to install a roll-in shower is financial, because the low-income tenant cannot pay the expense to install and remove a roll-in shower. Our access code must make changes to install a percentage of roll-in showers in newly constructed apartment units. Thank you, Darasher and Kevin. The new TCAC funded apartments in Elk Grove had accessible units, but none had roll-in showers, as they are not required, and that needs to change. Thank you, Helen Hong and everyone. And that was our last comment in the chat. And I'm gonna go ahead and unmute Whitney Prout.
Can I, Councilmember, sorry, Chairperson, how should we respond to these comments? Do you want to take them one at a time?
We do not need to respond to any comments unless you want to. Keep in mind that this is a deliberation of the council to decide whether to move the draft into public comment. So you do not need to respond unless you think it would be useful to your deliberation to do so.
I'd like to respond briefly to Ms. Arnold.
Go ahead, council member.
Ms. Arnold, while I agree wholeheartedly with you on the need for roll-in showers, that is not within the scope of these regulations and is handled generally at this point by the state architect and HCD and not DFEH. We have not, this body hasn't addressed a physical accessibility. So I just want to let you know that this is a serious issue, but it's not within the scope of this rulemaking. And I appreciate the significant problems that tenants with disabilities face. That's it.
Thank you, council member. Ms. Prout, thank you for joining us.
Yeah, absolutely. Thank you to the council, as always, for your consideration of all of our comments, and to the new members of the council. Hello. All of us at the California Apartment Association look forward to working with you on these regulations as they continue to move forward. I just wanted to offer a few quick comments. The first being to actually give you all an update. I know for those of you that I've worked with in the past, you know me personally, but Director Kish, specifically to your question about my input, I wanted to let you all know that I'm actually not going to be the point person on fair housing issues, or the council specifically for the California Apartment Association moving forward. Just my job responsibilities have changed a little bit. So you'll see one of my colleagues appearing here in the future, so don't be alarmed by that. I've just taken on different responsibilities. So to your request,
we will miss you greatly. We really appreciate your thoughtful comments, Ms. Prout.
Well, I will miss you all too, but I'll still be here in the background. Don't worry. I just didn't want you to think I had fallen off the face of the planet when you see someone else at these meetings in the future. So there's that. But to Director Kish's request specifically that I weigh in on this consideration of changing the word parents to either relatives or family members in section 12140B2. Because I'm not the point person on this issue anymore, I'm a little bit hesitant to weigh in too firmly. I'd certainly be happy to take that up with my colleague who will be the point person on this, and have a note to that effect in our comment letter that we submit during the 15-day comment period, of course, assuming the council votes this draft into it, which I feel pretty confident in assuming will happen. My sense is that broadening that from parents to include other family members would probably be fine, just because of the breadth of the statute itself. The primary issues that I've seen come up in this context are generally just really the issue of making sure the income is lawful and verifiable. And we've raised comments to that effect in the past that I do believe have been addressed in some of the revisions that have been made in the last couple of rounds. So thank you for that. So that's my initial take on it. But like I said, I'm a little hesitant to be any more definitive than that, just because, you know, I want to stay in my lane for lack of a better phrase. And then I also noted that the council, or the subcommittee in this latest draft, did address one of the issues we've raised in terms of the aggregate income issue in 12142, and aligning that a little more closely with what statute says. So thank you for that. Beyond that, I personally have not had a chance to look at this draft very closely. As you may all be aware, there's been a little bit going on in the landlord-tenant context in light of COVID and the new state rental assistance program. So we've all been very focused on that. We will absolutely be reviewing these in greater detail, and as always, we'll submit written comments. So thank you for your continued work. And unless there were any questions or comments directed to me specifically, that's all I had.
Thank you. Any other public comments?
Yes, I'm going to go ahead and unmute Tina Rosales.
Hi, good afternoon, council members. This is Tina Rosales with Western Center on Law and Poverty. I just wanted to take the opportunity to thank y'all for going over the regulations and to inform you that Western Center looks forward to the opportunity to provide a public comment on the regulations, assuming the committee passes these. So thank you very much for your work, and we look forward to working with y'all in the future.
Thank you, Ms. Rosales.
Okay, and I'm now going to unmute Matthew Oglander.
Hello, good afternoon, everyone. My name is Matthew Oglander. I'm with the San Francisco Human Rights Commission and want to thank all of the commissioners for your work, especially the new commissioners who have showed up and dove right into the material and the details of these regulations. I really appreciate the process. The regulations are very helpful for folks trying to, look at the law and figure out how to handle particular issues. I do have one specific area that I'd like to make a suggestion, and I will plan to submit written comments if and when that is possible. But the suggestion I have is to consider adding language regarding discriminatory statements. So that would be in Article 6, Section 12050. And the issues would be to clarify whether any particular types of damages are necessary in order to establish liability for discriminatory statements, and also what kind of damages can be recovered for a discriminatory statement or advertisement. Those are issues that have come up in some cases that I've worked on as areas where there was some confusion or lack of clarity, and I think it would be very helpful. Again, I will plan to submit written comments when possible, and thank you all for your work on these issues.
Thank you, Mr. Oglander.
And now I'm going to unmute Kareem Drisi.
Hi, good afternoon, Mr. Chair and council members. Kareem Drisi with the California Association of Realtors. Just wanted to take this opportunity to thank the council for considering our prior input. We very much appreciate it, and are currently in the midst of reviewing this current iteration, and certainly look forward to providing additional input during the next comment period, but definitely wanted to take this opportunity to thank the council for continuing to consider our input. We very much appreciate it. Thank you.
Thank you, Mr. Drisi.
And that was the last raised hand. There's no other comments in the chat, and we have received no additional emails.
Okay.
But thank you to all who commented. So thank you.
Yes, thank you.
Thank you, Council Member Iglesias and Shore, for the tremendous work you have put into this process and these regulations. I believe there's an action item for us to vote on the current form of these regulations. Is that correct, Mr. Kish? Kevin Kish?
I think that we have to go through and list each of the proposed changes. And since there are quite a number of them, what I would propose is that we make the motion, well, that Kara go through them, pausing slightly after each one. And if there's Adam, you want to weigh in? Oh, no, sorry. I was reading your face on the Zoom, a casualty of remote meetings. Kara, read each one, pause. If there's a council member who does not want to make the change that's been proposed, say so, and we'll just remove that change and consider it during the public comment period. And on those that there's no disagreement, at the end of the reading, there will be a motion to adopt those changes into the text and a vote. And then there will be a motion and a vote on moving the text into the public comment period. Does that sound right to everyone?
Yes, and if it's helpful, I have taken pretty detailed notes on the suggestions for changes that were made during the meeting.
Great.
It's up
So
to you, Councilmember. Sure, I also have notes. So do you want me to get started and you can supplement, or vice versa? Okay. I can get
I
started.
think it would be helpful if it's okay for Kara, us to take the lead.
Sure.
And then if there's a note that Councilmember Shore or anyone else has a different notation on, then they should weigh in.
Okay. The first suggestion was made to page 12. It's section 12042. It is currently sections G, 2, and 3 are currently labeled as section G. Councilmember Hong said they should be changed to I, but now subsequently I think they're going to change to J based on subsequent comments. I know that was a lot to follow.
I think the earlier one.
There were several earlier changes.
Yeah.
Councilmember Iglesias, go ahead if you want.
One is in the definition of military service, we did agree to delete the phrase, what was it? Let's see. Hold on.
Oh, I think she's doing it in order of suggestions, not in chronological order.
Yeah, sorry, I was doing it in order of who made
I think, it might be difficult to follow that way, but I guess that makes sense because that's how your notes are.
I mean, we can do it either. It's up to you.
If it's easier, I have mine in order of the regulations, but I defer to you.
Okay. I mean, it's up to you. Do you want me to just go in order of?
Then we'll supplement. We'll supplement with Councilmember Shure and Iglesias. Anyone else?
Yeah.
Okay.
Then you have to tell us which page you're on, Kara, please.
Sure. I took notes on that for sure. So go to page 14. And we're looking at section G and section A. Right now it says, let's see. So there's an us, and we're going to change it to an is. So right now it says, let's see. So I'll read it out loud. It is unlawful to use words or phrases that explicitly express a preference or limitation based on protected class. And then moving forward, in relation to a housing accommodation meeting the requisite criteria of Government Code section 12955.9 pursuant to section 12051E. No Section 8 allowed, no vouchers or government assistance accepted, no wheelchairs allowed. So I think what we are going to put there
we're
is
adding an or there, right?
Government assistance and no wheelchairs allowed. We're going to add or. Then.
Those are the two changes I have in that section. Us to is and adding or. So I would concur with that.
Okay. All right, moving on to page 15.
And I have a comma at the end of that subdivision.
Okay.
Sorry, what? What'd you say, Adam?
A comma at the end of the subdivision, correct? I believe someone erased that.
I think all these subdivisions have periods at the end.
Indeed they do. Apologies, my notes are off.
Is that a problem? Should they have commas?
I don't think so, as long as they're consistent.
Okay.
How do folks feel about adding a comma in that same section after, for example, e.g., comma, no blacks allowed?
I think that's one of those things where for consistency, we would need to do it throughout the regs. And I think currently, at least in this set, we don't put that other comment, but I understand it's the appropriate grammatical thing to do.
Okay. I think this is was withdrawn, but on page 15, in section 12051, little b, this was the section discussing for a person sharing the living areas in a single dwelling unit to use words stating or tending to imply that the housing being advertised is available only to persons of one sex. There were some comments to change that language. I believe we agreed you agreed to either look at it or not make a change at this time.
Yeah, there was agreement not to change at this time, to leave as is.
Okay. All right, and then move on to page 19. All right, we're on page 19, section 12140, little 3. Councilmember Hong suggested changing the age of foster youth, that's the last sentence, and foster care benefits, including benefits for youth up to age 21. She suggested changing that to age 26. Does that sound correct?
Yes.
Okay. All right, moving on to the next page, page 20. Let's see, section 5. Oh wait, no. Let's see. So this was the reference to the rapid rehousing. Let's see. Oh yeah, moving down, sorry. It said rapid rehousing, but we agreed that we wanted to change the language and elaborate a bit and say rapid rehousing or other similar assistance.
Yeah.
That sounds right. Okay.
Yeah.
So, or other similar assistance for homeless individuals? Is that what we're saying?
Yes. Okay. Move down to page 26. And we're in, let's see, section B. And this was, so I'll read it. It's the last sentence of section big B. A reasonable accommodation request that is made during or following a pending unlawful detainer action is subject to the same oh wait, no, that's not the right one. It's a request for a reasonable accommodation or modification in an unlawful detainer. Actions can be made at any time during the eviction process, including at or after trial and in oh wait, no, this is not. This is when we're deleting the word pending.
Correct.
Council members, remind me which section this is in, sorry.
It's the same.
You're in the right place.
I am in the right place, sorry.
Yeah.
Okay.
Where it says a reasonable accommodation request that is made during or following an unlawful detainer, so remove the word pending.
Yes, thank you. I appreciate your assistance in that.
And Kara, before you move on, I believe reasonable modification needs to be underlined there.
Okay.
It was a change made in the before at the beginning of the process.
Okay. Okay. All right, I'll move to page 33. And this was the comment on workmanlike. And I believe you agreed to. Oh wait, it was oh wait, we agreed not to make a change. Ms. Prout said that it was found in 24 CFR 100.203. Is that correct?
Right.
Yeah, we agreed not to change.
Okay. And then on section 4, it says case by case determinations. And we're going to take out the S. It should just be case by case determination. That's the 4th sentence down. Interior modification is reasonable is a case by case determination.
Correct.
Okay. All right. Now we're going to go back up. Sorry, guys. Page 15. Good thing I
Page?
page 15.
Okay.
You're going to move back up. And this is section 12050. Hold on. And then that's going to be section, let's see, any, so it's section D5. And it's any Councilmember Walensky suggested, and we agreed to make the change from, and this is the fourth sentence down, and it starts with discrimination or prohibition based on a protective class. And we agreed to say any protected basis under the act.
Yeah.
Correct.
Okay.
Yes.
All right. And then, sorry guys, this is like a, let's move down to page 19. This is the example at 12180C4. Oh wait, no, it goes down. Let's see. Oh, sorry. This is B2 on page 19. And this was the change suggested by Councilmember Alude, from parents to relatives or family members. I think we agreed we were going to go back and you were going to
think about it.
Yeah, okay, just making sure.
I would recommend that we change it to family members, and then we can think about when we go back whether we want it to be relatives or family members. But I do think we agreed we should broaden it. So I'd like us to pick one term there, and then we can always consider whether it's the right term.
I'm okay with that.
So you're agreeing to change from parents to family members. Okay.
And then we will consider in our discussions whether we want to use that or relatives.
Okay. And then moving down to page 21, we're in B. So in section B, we discussed removing the duplicative language in section 3. So then it would be renumbered B 1, 2, 3, 4.
Correct.
1, 2, 3. Yeah. And there's a period that needs to be made into a comma after the word disaster there also.
Oh, that's right. That's a comma. All right. And then let's go to page 39. We're almost there. There's a couple more. All right. So we're on page 39, and this is example 4 that starts with reasonable accommodation request for additional time to perform a housing related action. And Councilmember Alude suggested that we changed from mortgager to mortgage company to mortgage servicer, and suggested an additional change. Let's see. So without this accommodation may be necessary because without it, Tuan may be unable to sign the loan modification application, and if so, receive the loan modification. So adding modification to the end of that sentence.
If it's helpful, Kara, I can go through, and there are about 5 changes in this paragraph as a result of this suggestion. Do you want me to go through?
I would very much appreciate that, Councilmember. Sure.
So the first one, and someone can correct me if I'm wrong, is in the second sentence. He requests a reasonable accommodation for additional time to come into the mortgage servicer's office as opposed to mortgage lender. And continuing in that sentence, stop me if I'm going too fast. Continuing that sentence, comma, even though the mortgage servicers, servicers apostrophe S, normal practice is to give a little advance notice of the meeting. That's the first 2 changes. The next sentence is this accommodation may be necessary because without it, Tuan may be unable to sign the loan modification and so receive the loan modification, period. The next sentence should read the mortgage servicer as opposed to the mortgage company must consider the request. And then there's no changes until we go down to the second to the last sentence, which says, since processing loan modification applicants is part of the essential operations of the mortgage servicer, comma, instead of mortgage company. And then I think I've got them all.
Thank you, Councilmember Scher.
Thank you.
Does that sound right?
Yes.
Okay. All right, we have two more. Go back up to page 6. And this was the discussion of the military or veteran status. And I think we agreed to delete in section 6. The second sentence after 38 USC section 106A1, the council agreed to delete regardless of duty status.
Correct.
Okay.
That's correct. And we're going to take into consideration some edits involving subsection 7, but we aren't making those now.
Okay. And then page 11, this is the last. And so we're going to little section C. So little section C would stay the same. Section 1 would change to section little d. And then section 2 would change to section 1, and section 3 would change to section 2. And then we would renumber the rest of the section. There's also some cross references that we're going to have to fix.
I believe the cross-reference changes are on page 12.
Oh, moving it to J, right?
Yes. J 2 and 3. The cross-reference will become 12042 J1.
And those are all of my notes of changes.
Maybe I missed it. Did you get one on page 20? B5 for homeless individuals, rapid housing or for other, you got that one? Okay.
Yeah.
Before we move on, I wondered if subdivisions 2 and 3 on defining direct evidence go under C instead of D, the new D.
They do go under C, not D.
Yeah.
Okay. Thank you.
Did you get one on, did you get the page 14 change? Which
The is to, the us to is and the no wheelchair allowed will have an or before it.
that one, okay. And then
I think we got page 26. Did we get page 26? Yeah.
oh, B,
Mhm.
you
The
got that one?
pending,
We got that one.
we got that one.
We got determination.
How about page 14? Did you get one on page 14?
That was the one from before, the us to is and the no wheelchair allowed.
Oh, right. Yeah, never mind. I just missed it.
I think you caught them all. Kara, nice job. I don't have any others.
One item on page 11, is that supposed to be expressed bias or express bias as a terminology?
Where on page 11? I'm sorry.
Page 11, it's direct evidence also includes an express bias.
Mm-hmm.
It should be ED or is it an express bias?
I think express bias is what we're intending. as opposed to an implicit one.
Any other changes that we haven't covered yet? Okay. All right. So do we have a motion to adopt the edits and amendments that have been just identified by Kara Broadfuhr, as supplemented by Councilmember Scher, as well as other council members?
So moved.
With regard to these regulations, housing regulations regarding definitions, intentional discrimination, discriminatory notices, statements, and advertisements, consideration of income, residential real estate related practices, and disability.
So moved.
You have a second?
I second.
Okay. Can we take roll call, please?
Yes. Chair Sandoval.
Aye.
Councilmember Brodsky.
Aye.
Councilmember Hong.
Aye.
Councilmember Iglesias.
Aye.
Councilmember Alude.
Aye.
Councilmember Scher.
Aye.
Councilmember Walensky.
Aye.
Thank you, everyone, once again, and Councilmember Scher and Iglesias.
So
next,
wait, if I understand, Director Kish, so we just took a vote changing.
Right.
Now we have to take a vote moving it into next public comment.
do we have a motion to move these regulations as just approved and amended by the council for another round 15-day public comment?
I
Do you have a
move.
motion?
I move.
Thank you, council member. Do we have a second? Thank you, Councilor Brodsky. Okay, can we take roll, please?
Thank you. Chair Sandoval.
Aye.
Councilmember Brodsky.
Aye.
Councilmember Hong. Councilmember Iglesias.
Aye.
Councilmember Alude.
Aye.
Councilmember Scher.
Aye.
Councilmember Walensky.
Aye. And I believe that Councilmember Hong might have been muted earlier when she was trying to speak.
She's back.
Councilmember Hong, do you want to?
Can you tell me what the motion was? I'm sorry.
Sure. This was the motion to move into another 15-day.
Oh, yes, yes, sorry.
Okay.
Great.
All right.
Thank you. All right, thank you, everyone. We are next moving on to item number 8, which is an update regarding the April 30th, 2021 hearing on the use of algorithms in employment, housing, and lending. Director Kish, do you have, or Kara Broadfuhr, or Adam Romero? Go ahead.
Thank you. I think this one, Adam, you're going to take.
Oh, sure. So as the council, I think, is aware, we've been looking into the issue of algorithms and bias in the employment, housing, lending, and healthcare contexts. And we've been making progress toward a civil rights hearing tentatively scheduled for April 30th of this year before the council. We're lining up some terrific experts in the area to collect sort of all that we know on this issue right now and to advise the council on potential rulemakings or other actions that the council might take. And we look forward to, hopefully the council will agree to create a subcommittee and working with the department on finalizing the plans and moving this forward.
I just want to say thank you very much to the department and to Kara and Adam for doing the research and getting this together. I think it's super important. And I'm glad we're hopefully going to move forward into some regulations on it.
Very excited. Thank you.
Any other council member feedback? Do we have any public comments on this item?
We have no public comments on this item.
Okay.
I see a raised hand from Mr. Ken Wang.
Oh, thank you, Adam. Let's see. All right, Mr. Wang, I'm going to unmute you.
Good afternoon, Chair and Council members. My name is Ken Wang, and I'm here on behalf of the California Employment Lawyers Association. I just wanted to commend the department and the council for putting together this issue briefing on the use of AI in employment, housing, and lending. As worker advocates, we welcome this important conversation among policymakers and regulators in this issue area that will have a tremendous impact on workers. Hiring tools that use algorithms, machine learning, and other techniques are becoming cheaper and more widely available. These tools have helped employers save on HR costs while expanding the pool of potential applicants, and some have even purported to reduce and eliminate bias in hiring. However, these technologies also make opaque the process by which hiring decisions are made and may serve to obscure bias in the hiring process. Complicated machine learning algorithms are not susceptible to examination, and even developers of these tools often have difficulty explaining why a certain result is reached. This is why it is important for policymakers and the public to grow our understanding in how these tools operate and where policy interventions may be needed to increase transparency and prevent discriminatory results. Particular attention should be paid to the role of both the technology vendors and employers, because each have a unique perspective on the development, implementation, and decision-making in the hiring process. And both should share the responsibility to be transparent in the way that their tool and the hiring process treat applicants. So thank you again for your attention on this issue, and we look forward to the briefing.
Thank you, Mr. Wang. Any other member of the public, Kara?
I see no other raised hands. We've received no emails and there are no chats.
Okay. Thank you. We'll be moving on to the next item, which is an update from the Reasonable Accommodations for Associational Disability Subcommittee, which currently has a member of one, Councilmember Dale Brodsky, and so we're looking to add to this committee. Go ahead, Councilmember.
Councilmember Brodsky is on mute.
Thank you. What I was going to say is I'll try to keep this brief, but I do want to, am looking forward to having someone else join me on this subcommittee, and welcome aboard to all to our new members. It's great to have you. Just by way of background, on December 4th at our last meeting, the council approved a request for public input on this issue of whether employers have a duty to provide reasonable accommodation for employees who associate with someone who has a disability, even when the employee or applicant does not themselves have a disability. And we received about 15 or so separate comments, but a number of the comments were on behalf of either many organizations or an individual. So it was really a good response. We are in the process, the department is in the process of evaluating and synthesizing the public comments before we determine next steps. And so that will be happening, and I'm hoping that we can have some, figure out what we should be doing with this in the next, by the next meeting at least. But I don't know, Chairperson Sandoval, do you want to open it up now to see if someone's interested in joining me on the subcommittee or not? Let me also add that this came out of the Castro Ramirez case in dicta, and that case was from 2016. So it's been kind of on our radar screen for a long time, and the court defined, it's using the court's definition in dicta, not a holding, about what constitutes a disability. And so that's where this comes from. And on the website, if you haven't familiarized yourself with the request for public input, which kind of gives some background, you can get it on the council's website, or I can just send it to you. But anyway, anybody interested in, I don't know how you want to handle it.
Councilor, I think this would be a great time for other council members to ask questions of you with regard to what you envision in terms of the work that will be involved with this committee. and then we can make a decision once we address that agenda item subsequent. So I think it would be a good opportunity for them to ask you questions if they wish to explore further what the committee will involve itself with. Before then, we have a council member, Sure, who wants to make a comment. Go ahead.
I think this is a really great endeavor, and I know it's one of the first times we've sought. We occasionally do seek public comment in advance of the rulemaking process. I'm hoping we will find you another council member to work on this with you, Councilmember Brodsky. I want to say that although this arose in the case of an employment case, this is an issue of overarching importance on all of our regulations impacting people with disabilities, not just employment. So it is an important inquiry.
Any takers to join me? So what will happen is, I mean, if we do end up, as I say, we're evaluating and or synthesizing the public comments now, but assuming that we could move forward, it would it could be part of the regulatory process. But at this point, it's working through that, so it's a work in progress, would look forward to having another person on board.
Great. Okay, so we could address that. Again, any council member wants to ask any question or provide any additional input? All right, we'll address committee assignments when we get to that in the agenda. Do we have any public comment or anything else to add, Councilmember Brodsky, before we move forward? Councilmember Brodsky, do you have anything else to add before we take public comment?
No, nothing. I know.
Do we have any public comment, Kara?
No, Chair Sandoval, we've received no public comment.
Okay. Great, we're moving on to the next two items, which involve Gabriel Sandoval. So I will address them concurrently. So we did have a hearing last fall where we had a day-long discussion on issues related to barriers that continue to exist for those individual community members who were formerly incarcerated. We are looking at the items that were discussed, and as I understand it, a memorandum that provides a synthesis of what was discussed and potential avenues that we can take or provide recommendations will be forthcoming shortly. We're also considering combining the other committee, which is a Criminal History and Work Opportunity Tax Credit, with this particular hearing subcommittee. With regard to the Work Opportunity Tax Credit regulation, as noted previously in a meeting, I believe in December, the draft has been prepared, but I believe that it may be informed in part by what we put together with regard to the hearing, so that there would be a more coherent regulatory package, if in fact that is the path we take. So I also want to make mention to the new council members, this is also a council subcommittee of one. So I welcome any participation in this, what I believe and will suggest would be one subcommittee as opposed to two at this time. So thank you. Do we have any council member input? Okay.
I think the idea of combining it into one subcommittee is a really good idea. So I support that.
Thank you, Councilmember Iglesias. Okay. Anybody else? Any public comment?
No public comment.
Okay. All right, so let's move next to the update from Government Code Section 11135, Regulations Subcommittee. So I'll hand this off to Councilmembers Brodsky and Councilmember Short.
Thank you. Really not much to report. The regulation is still, the draft regulation that was approved by the council is still under review by the reviewing agencies. And we have our fingers crossed that we can report more progress at the next meeting.
Thank you, Councilmember. Councilmember Brodsky, would you like to add anything before we move to public comment?
No, that's
okay.
about it.
Thank you. Kara, do we have any public comment?
We received 3 email public comments, and I'm going to summarize them and then I'll forward them to the council. We received an email from Kevin Baker from the ACLU expressing support for moving forward with our rulemaking on 11135. We received a similar comment from Liz Gillian from Public Advocates, also expressing support for our rulemaking action under 11135. And also, we received a comment from Joanne Lee from the Legal Aid Foundation of Los Angeles, also expressing support to move forward with our rulemaking action, especially in light of the COVID pandemic. And again, I will forward these to the council.
Thank you, Kara.
Oh, and it looks like we have one hand raised. So I'm going to unmute Thomas Coleman.
Hello, can you hear me?
Yes, go ahead, Mr. Coleman.
Okay, thank you. I have 3 points that I'd like to emphasize about the importance of these regulations. And basically to summarize all of them, is that the courts in judicial proceedings continue to violate the ADA and 11135 on a daily basis. So I think it's important that the regulations stress that disability non-discrimination provisions of the statute and regulations apply to judicial proceedings, and especially to probate conservatorship proceedings where virtually all respondents have major cognitive and communication disabilities. Secondly is for the regulations to stress that these non-discrimination provisions include the need for courts to modify policies or provide accommodations, not only within the courthouse as far as judicial proceedings, but as well as ancillary services that are related to the case that are occurring outside of the courthouse. And the third point is the need for the regulations to somehow take into account or address the problem with Rule 1.100, the California Rules of Court, which is totally inadequate to serve the ADA needs of involuntary litigants with major cognitive disabilities, people who cannot realistically request an accommodation. And as we know, Title II imposes duties on courts to provide accommodations or make modifications for known or obvious disabilities, even without a request. So I just hope that somehow the rules or the regulations, emphasize the need for the courts to deal with this even without request for known or obvious disabilities. And then finally, 2 last points regarding resources that are available when the council may get back into drafting or redrafting or making any changes, and that is the publications on the website of Spectrum Institute. There are specific, if you go on the Spectrum Institute website and click on publications, it'll take you to a bibliography, and there's a section on commentaries on the ADA. And there are 2 particular documents that I think are of importance to drafting these regulations. One is a DOJ guidance memo on criminal justice courts and agencies, where the guidance makes it clear that the ADA applies to, criminal justice proceedings, again, inside and outside of the courthouse. And then there's a joint guidance memo between the DOJ and Health and Human Services Agency, a guidance memo on how they apply to child welfare proceedings. So I think that there's a lot to be gained from looking at those 2 things. And then the final resource is the Washington State's courts have a General Rule 33 dealing with accommodations, and they clearly specify that appointment of counsel may be a necessary accommodation to be provided to people who, have cognitive disabilities and can't navigate the system themselves. So with that, I just, thank you for what you're doing, all that you do in all of the aspects, but particularly this 11135 is an important new tool that will help those of us who are trying to make sure that judicial proceedings are, provide access to people with cognitive disabilities. So thank you.
Mr. Coleman, can you just say for the record what organization you're with?
Oh, yes, I'm sorry. So I'm the legal director of Spectrum Institute, which is a nonprofit that advocates for people with cognitive disabilities and especially for conservatorship reform. And I mentioned the website, it's spectruminstitute.org.
Thank you.
Mr. Coleman, thank you. We've appreciated your comments on this, and we are all looking forward to being able to release the next draft for public comment. So
okay, I guess I'll have to hold my breath, but I can't wait.
Thank you very much.
Okay, thank you.
Thank you. Any other public comment, Kara?
Yes, I'm going to go ahead and unmute Sylvia Yee.
Hello, thank you, Kara. Dear council members, I appreciate your update on the subcommittee's work on Government Code Section 11135. I and my organization, Disability Rights Education and Defense Fund, where I am a senior staff attorney, would like to thank the subcommittee for your work and urge continued speed moving forward. The importance of your work was particularly highlighted recently for the disability community by the events of COVID-19, where people with disabilities encountered the potential for discrimination in at least two specific areas. One was in the area of discriminatory medical rationing and crisis standards of care guidelines that are being developed by hospitals all over the state, as well as in the failures of many of these same facilities to modify their visitation policies for people with disabilities and their support persons. These two issues are literally life and death matters for people with significant disabilities of all kinds, and implicate institutions and facilities that, for the most part, receive state funding and would fall under the auspices of Government Code Section 11135. Having these regulations in place, strengthened, and clear investigative powers in place would be something that would be very important for disability advocates and people with disabilities in the state. Thank you.
And Ms. Ye, I want to also thank you for on behalf for Dredef's input to the associational disability inquiry. I appreciate that. It was very, very thoughtful.
Thank you. We appreciate your recognition of that.
And we look forward, and thank you, Ms. Yee, and we look forward greatly to continued input when we are through this lengthy internal review process and can release the draft for public comment, because many of the issues you are raising may need some public comment, as the draft that will come out was actually completed prior to much of the pandemic issues. So we are looking forward to being able to get through this process and release it to get input by all of you on the draft, and that will be notified. All of you who are on the DFEH website will get notice of that. It will be publicized there.
Thank you.
Thank you.
And there is no further public comment.
Thank you, everyone. We'll move now to the update from the Hate Violence Hearing Subcommittee. Councilmember Brodsky. You're on mute, Councilmember.
Thank you. That's so I'll shut up when I'm supposed to shut up. The hearing was conducted, on hate violence some time ago, and we're going to be going through and haven't completed a review of all the transcript of the comments, but at some point we will do that. Councilmember Sandoval and I, he in person and me online, attended a press conference yesterday by the LA Human Rights Commission on issues of hate violence, and I'm so glad that you were there you were able to be there in person. But there's a lot going on, as we all know, headlines, multiple articles in both, local and national newspapers about what's going on. So this is a timely issue. We need to figure out what we can help do in our role as council members, and that's what we're trying to figure out. anything else to add on that?
Yeah, and thank you, Councilmember. I have been horrified by what has been taking place over the last several years with regard to the hate against the AAPI community. And there is a lot of efforts that are being undertaken, not only throughout the state of California, but across the nation. And I think there is an opportunity here to think more creatively in terms of what our council role is or can be. But I also need to underscore that the council is working on these issues and have been working on these issues related to hate, violence, hate incidents as identified by Councilmember Brodsky. But also the DFEH has put on some webinars and put out some communications to the broader community as to what needs to be done if in fact an individual believes that he or she is the victim of a hate incident and or violence, whether you're talking to law enforcement or you're talking to the DFEH or some other organization. So Councilmember Brodsky and I are thinking through what, in addition to what was done in terms of the hearing, synthesizing that and see what are some potential next steps. But one item that I've identified just in terms of conversing with different individuals, not only at the press conference that was mentioned by Councilmember Brodsky, is the fact that many individuals don't understand the breadth of resources that may exist for that individual. So they go to law enforcement and the law enforcement entity decides that it may not be a crime. There's no cross-referral or indication that there's some other entities where that individual can find some type of relief or compensation by way of actual damages, punitive damages, civil penalty, restraining order, those kinds of things, because I think that's important. We need to get data to see what is being done in response to concerns that are being raised, and we already know there's underreporting. So this is an important issue for all council members, for the DFEH, and so Councilmember Brodsky and I are thinking more broadly about what is it that we can do in addition to, yes, we are charged with the responsibility of promulgating regulations, looking to see if there's any need to promulgate regulations in this regard. But also there's a tremendous need of creating more opportunities to educate the cross-section of communities that are impacted adversely by this type of hate. So that's all I have to add at this time.
I would just say too that one thing that impressed me with the LA, the Human Rights Commission's approach is that they have a number 211 that you can call, and that emergency number. And I don't know whether it's statewide or if it's just local in LA County, but that might be something that I was thinking that if we could get that on a statewide basis to some connection, you know, I don't know what the council's role can be in that, or DFEH, it would be really more, I guess, you know, have the media exposure to do something like that. But the reporting is really important. And then as Councilmember Sandoval said, how do we communicate to people that there may be remedies out there other than criminal that people can avail themselves of? So we're trying to think out of the box here, and welcome.
Yeah. I appreciate working with you, Councilmember Brodsky, and also all the council members. But what's interesting about the report that was issued, where it showed up to close to 4,000, 3,800 incidents of hate throughout the country, is that there were some examples where it seemed as if there was no understanding, or there needed to be a better communication with somebody who had been the victim of a hate incident, that there are other recourses that can be taken if in fact it's deemed to be not cognizable under our criminal laws for prosecution. So there's an opportunity there to create some more education on that front.
And maybe that's something that, for example, DFEH could do in the form of one of a poster that could be sent to law enforcement agencies, for example, to apprise them of, you know, what other resources there are for people who you know, reports end up in the criminal justice system but don't go anywhere. They just, you know, or that they do go somewhere else, but that there are these other resources available. Just thoughts.
Do we have any council member input?
Yeah, so I really support and look forward to the committee coming back to the council with some specific recommendations so we can kind of move forward on this, and particularly this idea. I believe in the hearing itself, and maybe it was the Riverside Police Department that did that civil referrals. So they would be a model, and maybe we could draw on their experience and sort of their sort of validation of that as a police department in terms of that piece of it. So yeah, it's very important work. Look forward to your recommendations.
Thank you, Councilmember. Anyone else? Okay. Public comment?
Yes, I'm going to unmute Dr. Cliff Cheng.
Yes, this is Dr. Cliff Cheng speaking. I had been on the Fair Employment and Housing Commission Advisory Committee decades ago when George Wolverton was the chair of the commission. I've been in retirement. I was forced out of retirement 13 months ago when I saw a pattern of scapegoating and hate towards the Asian American people. I started collecting data and I started applying for grants to make a documentary and write a book, which I am currently still working on. I interviewed Angela Oh for the documentary.
I would just ask you to speak into your microphone because you're going in and out of the sound a little bit. Thank you.
Oh, okay. Yes, Dr. Cliff Cheng here. Formerly on the Fair Employment and Housing Commission Advisory Committee when George Wolverton was the chair of the commission. I was in retirement until 13 months ago when it became clear to me that we were in for another wave of scapegoating and hate against Asian Americans. I unretired myself, started collecting data. I am writing a book and making a documentary film to be the scholarly record of this current wave of scapegoating and hate. In 2017, there was a state audit of hate crime reporting. I'm wondering if you're familiar with that. I haven't heard anyone speak about that. It found great, it found patterns of underreporting. It found that major police agencies in the state were doing a inadequate job. When I was LA City Human Relations Commissioner, I was also on the Hate Crime Task Force of the LA Police Commission. And the late, great Rose Ochi and I worked very closely trying to get LAPD to improve its reporting and its knowledge about hate incidents and hate crimes. Evidently, that has faded away. There are victims that I am personally helping who 3 times tried to report to LAPD, and LAPD did not report until I intervened and personally took the case to Deputy Chief Blake Chow. That was just for a report, and then they didn't write all the suspects on the report. They did get a TRO. When they went for the restraining order hearing, the judge made very derogatory comments toward the victims and had them in tears. There's work that needs to be done not only with police agencies, but with the judiciary as well. I would urge you to look at both. Also, the shootings in Atlanta the other day, I haven't seen this reported in the media. I'm wondering if any of you know the significance of that day. It was the 30th anniversary of the killing of Latasha Harlins. If you're unfamiliar with the case, she is the African-American teenager who was shot dead, allegedly over shoplifting in a Korean-American grocery store in South LA. This was 3 weeks after Rodney King was savagely beaten by the LAPD. When the LA riots occurred, 65% of the businesses damaged in the riots were Korean American. That was payback. And I'm wondering if there's a connection between the shootings in Atlanta, which targeted 6 Korean American women, as well as 2 other people, and the anniversary. So there you have it. Back to you.
Thank you, Dr. Chang, for your comments. Kara Bradfield, do we have any additional comments, public comments?
We have no additional public comments. Thank you.
Let me just, a comment did come in from Mark Murray, who Mark has attended many meetings and he had to leave. He just wanted to, and he's there on behalf of the California Teachers Association. He wanted to mention that 211 is a statewide number. And he said that it is provided by the Public Utilities Commission, but local counties are able to customize the services available when someone calls the number. So I don't know if they're all hooked, linked to hate violence or not, but that's a good piece of information to have. So thank you, Mark.
Councilmember Hong, I see that you have your hand raised.
The only other thing that I wanted to just put in context, so in the California Justice Gap study, when people encountered a civil legal issue or a problem, the first and foremost resource that they go to are family and friends. And then after that are trusted advisors and nonprofit organizations. I think generally, especially if you are from an underrepresented, under-resourced community, law enforcement isn't the first place you go. And particularly, right, if you are not only Asian, if you're LGBTQI, if you are undocumented, I think we just, and I know that you're sensitive to this fact, but I also, we're looking at it from a systems standpoint, but not from a people standpoint, right? And so when we're looking at this type of campaign, it's also for the victims and the survivors of these hate, but then all those who are perpetrating it and building awareness about their behavior as well. So I just want to put that in context and to commend that work. I'm really excited about the subcommittee and being involved in that as it comes to the committee, but I do want to put that in context of how we can be proactive about like a rainbow banner about being LGBTQ friendly, how we can be friendly for all people and creating that environment so that it is a momentum against hate versus something where it's constantly punitive and focused on criminal action.
Do you, great thought. I just have a question for you. Do you have any kind of source or something we could look at that has studied where people do, who they do vent to, if you will, when these things happen? I mean, I was thinking the criminal, the police come into it when they're actually arresting somebody and they've got a victim. And that's where I wasn't thinking so much that the person would necessarily, because I know it's underreported to police departments, hate violence is in general. But it'd be really helpful to know, to see who does get, who are the, who does get the information first, because that would help kind of maybe help us figure out who should be targeted in terms of notifying people of resources.
I don't know narrowly as into hate crimes. I mean, I'm happy to look that up. But I would assume hate crimes very much like sexual violence and perpetration, right? It's an issue of shame, right? And on top of it all, of not knowing, kind of like sexual harassment, does that really happen? Was that really because of race, or was it like what's happening in Atlanta? Is it not race? Is it just misogyny and gender, right? Like, I feel like there's a lot of excuses for it. And so, again, it's always tends to be family and friends. But then, you know, how do we talk about those communities together, whether or not that's churches or nonprofit organizations
Or
that
medical, I mean, medical providers maybe, you know, I mean, that might be another.
Yeah. And during the hearing, there was a woman, I forgot her name, a Latina, who works for a nonprofit, and she was making the same point, that people come to the nonprofit. So again, that would be another key thing, a nonprofit that represents people and works with people and advocates, that would be a key communication point.
Mm-hmm.
And Councilmember, I appreciate your comment and the underreporting and the challenge for individuals who are marginalized in the communities, particularly in terms of these acts of hate and violence. But I think of it as there's a spectrum of opportunities for us to figure out what are good ways to address or help address this particular issue, because it is going to require a lot of different stakeholders to get involved and feel responsible as members of the community. So I appreciate your comments on that. Okay. Any other comments? Okay. Let's move on to what we've all been waiting for, is the assignments for subcommittee members and interests that we have for new council members. We have, as I understand it, opportunity to create a subcommittee on the use of algorithms in employment, housing, and lending, which will require 2 members. We also have the reasonable accommodations for associational disability subcommittee, which will need 1, as well as criminal history and employment hearing, which will also include the work opportunity tax credit. So, any interest of any of the new council members to join any of those committees?
I would be interested in the algorithm one, in, you know, pending others' interests.
I too am interested in that subcommittee as well.
All right. Any other interest from any of the other 2 council members in that subcommittee?
I would also be interested, but I'm fine to defer. There are other committees that I'd like to support as well, subcommittees.
And I would say the same. I would be happy to be on any of the open subcommittees. So I'm happy to defer to those who.
Well, in that case, I'll sort of withdraw mine for the algorithm thing, so that the new members can get their first choice.
All right. So, anyone else care for the algorithms subcommittee?
Well,
so we have
maybe if we could do this, because I think all 3 of our new members are interested in that subcommittee, if that's correct. Can we talk about whether there's any interest in joining the criminal history and work opportunity tax credit subcommittee? I think that's a relatively discrete task that could result in pretty quick rulemaking to go into. And if there's someone who is interested in that, it might impact our staffing of the council's decisions on around who staffs the algorithmic hearing.
I'm interested in joining that subcommittee, and then would be happy to defer to the other council members for the algorithmic one.
And then I apologize, is the other one that we need a member on the hate violence subcommittee, Chair Sandoval?
No, it is the Associational Disability Subcommittee.
Of course. Is there any council member who would like to join Councilmember Brodsky on that?
I would like to. Yes, this is Aditunji.
Great. So it sounds to me like we've got a potential subcommittee for associational disability discrimination, of a vote to add Councilmember Olude. We have a vote potentially to add Councilmember Walensky to the criminal history and work opportunity tax credit. And we have a vote to create a subcommittee for algorithmic decision-making with Councilmember Hong. And who wants it most? I mean, I would say it's so awkward to do this publicly, but this is what we have to do. But since we have two new subcommittee members, Olude and Walensky, I would suggest that you say yes if you feel a burning passion, and if not, we could create this subcommittee with Councilmember Hong and Iglesias.
Perhaps, and maybe as a side suggestion, that would be nice, because then all the committee members have a veteran and a new one. And so for my own self-benefits, I'm not left hanging.
Exactly right.
That would also be beneficial for the subcommittee to have both perspectives.
And in fairness, I will say that Councilmember Iglesias has been pushing us for a couple of years on this topic. So I think it's only appropriate that we make him do some work.
And I'm researching this for my work part, so this is why I'm also self-interested on the tech part.
Okay, thank you. Thank you for your indulgence as I do a little direct solicitation, and thank you for your volunteering.
I think it's great. These committees sound wonderful. And honestly, if I wasn't already overcommitted between the housing regs and 11135, I'd love to be on the algorithm one. So I think it sounds like a great team. I just didn't want to flag for people that I put some information on the statewide 211 number in the chat. Sorry, that's sort of a side note.
Thank you, Councilman. Any other ideas for subcommittees, or are we good with the ones we have now? There is some thought about creating a community outreach subcommittee, kind of a general subcommittee on those types of issues, not really dependent on issues that are fixed, but are reflective of needs that may need to be addressed in terms of civil rights compliance or education. So just a thought.
Also talked about Unruh and Ralph, you know, Ralph may segue from the hate violence, but we have talked about a subcommittee on looking into Unruh regulations. Kevin, is that a signal that you're oh no?
Oh no, I'm sorry. Again, we've got Zoom gestural interpretation going on.
Is he holding his head because he says, oh no, don't say that?
I am cognizant of the amount of work that we are facing as a body. And I do see many potential avenues for rulemaking under Unruh and Ralph. In fact, some things have come up this week. If I were voting, I would form these subcommittees and revisit at the next meeting. But of course, you guys can vote to form another one if you'd like.
That sounds acceptable.
I'm so excited that we have people. We have 7-member body. You know, I mean, that's the best.
So can we have a motion?
For the assignments that we just discussed, Gabriel, right. I move. Yep. Do I need to put it in special words or?
You get a second?
I second.
All right. Roll call, please.
Chair Sandoval.
Aye.
Councilmember Brodsky.
Aye.
Councilmember Hong.
Aye.
Councilmember Iglesias.
Aye.
Councilmember Alude.
Aye.
Councilmember Scher.
Aye.
Councilmember Walensky.
Aye.
Okay. Any further public comments on any items discussed during today's meeting?
We've received no emails, no chats, and no hands are raised. So it does not look like there is further public comment.
Thank you for doing such a great job in your first chairing experience.
Well, thank you, everyone. And I must say that a lot of this has to deal with the support from Kevin and Adam and Kara, as well as, of course, our Kaya Mandabaum, chairing her. I appreciate the guidance and his way he did so well in this position. So thank you so much. All right, so we have a motion to adjourn. We have to move to adjourn.
So move.
Second.
Second.
All right, I think we're all in agreement.
Thank you all.
Take care, everybody.
Bye-bye. Thank you.
Bye.
Bye.